Hello everyone, John Dove here from Speed Mooting. Welcome to episode 5 of the Partners in Crime podcast. Yes, that's right, we're up to the 5th episode now. These podcasts are coming at you quite regularly now, and we're releasing episodes every single Friday. On today's episode, we discussed common mistakes in advocacy, our respective routes to the law. Hayley and I both had very, very long routes into this profession. Recent trips to London, we've had a fair few in the past year, and Hayley having her Law Society admission ceremony only 4 years late. And those trips to London include an interesting story about us having lunch with Lady Hale. And I talk about a first appearance in the Magistrates Court. So it's a fun episode, an interesting episode, and we hope you enjoy. Welcome to the podcast. Live. Hello, welcome to episode 5 of the Partners in Crime episode. I'm John.
And I'm Hayley.
So welcome along. We've made it this far. We were joking last time, weren't we, that this is a bit of a milestone episode and should do something special. I'm listening to this podcast at the moment, and the host, he names every episode after an athlete with a corresponding number for the episode.
I know where this is going.
Now, for those of you that know me and maybe have seen my social media, I'm quite the motorsport fan. I do a bit of racing myself. And I was quite the fan of Seb Vettel, who was number 5 when he drove for Ferrari. So,
of course he was.
We'll name this the Sebastian Vettel special episode.
But here comes Sebastian Vettel!
So anyway, welcome along. So we're pleased to be bringing you our 5th episode anyway. We're really getting into the swing of this, aren't we, Hayley?
Certainly are.
We're bringing you these episodes every single week. So hopefully you're enjoying the content. And as ever, as we always say, if you've got any questions for us that you want us to answer on the podcast, drop us an email. What's the email address, Hayley?
info@speedmooting.com.
But anyway, enough dilly-dallying.
Yep.
Let's jump into the podcast, Hayley.
Let's go.
So last week was a semi-busy week, let's call it.
Yep.
And at the end of the week, also known as the weekend, we were down in London, weren't we?
We were,
the capital city. So, London was graced with our presence. Mm-hmm. And 4 years after qualifying, what did you do, Hayley?
So I finally went down to London to attend my Law Society admission ceremony. So as John said, it was 4 years late because I qualified in May 2020, right in the middle of lockdown 1.
You must stay at home.
And then, I don't know what happened, it was just super busy with practice, so never got the chance to go.
Yeah.
And John and his mum and dad were very, very insistent that it's something I should experience. And you know what, I'm glad you all pushed me to do it, because it was a really, really good day.
Oh, it's a brilliant day, isn't it?
Yeah.
You know, there's just something about that building, and you know, the railings that you see all the way around with the little lion heads on them.
Yeah.
And obviously you got to get the obligatory photograph under the archway, haven't you?
Yeah. I mean, it's funny. It's almost like a rite of passage to get your photograph taken under that archway. So much so that there's actually a queue of people waiting for their turn to get the picture there.
Yeah, and we snapped a fair few, didn't we?
We did, yeah. I think Mum and Dad took about 50 of me.
Yeah. Good job it wasn't the olden days with the cameras with the actual rolls. We'd have run out.
But yeah, it was really nice. I think there was about 30 people.
Yeah, I think so.
At the ceremony, so it's a lot like graduation. So you get a certificate, you get a gown, you go up on stage, and we got to meet Mark Evans, the Vice President of the Law Society. He was lovely.
He was.
I think we did bend his ear a bit about speed moving at the same time. Never miss an opportunity.
Oh, never miss an opportunity.
But yeah, it was lovely. And for those who watched last week's podcast episode, we did get to have a nice little scoop in the City of York pub as well. So very, very nice.
Always good to go in there, isn't it?
Yes.
Yeah, I remember that pub from my days at Gray's Inn. We're not going down that rabbit hole again. We're not going back into the Harry Potter conversation.
No, although you finally finished.
I finally finished it. We finished it last night. Yeah, funnily enough, I actually predicted where the penultimate Horcrux.
Well done.
Oh,
That's
got
the
it
first
right.
time you said it right.
I've been saying Horlux all the time, but Horcrux.
Spoiler alert.
Oh, yeah. Sorry. If you've not seen the end of Harry Potter, mute your microphone for the next 60 seconds. Let's go. So I predicted it was going to be in a scar. So, so I'm proud of myself for that one. And you know what? It was a good ending. It wasn't a bad little film. I enjoyed them. They're not the Fast and the Furious, but they're good. I mean, I was half expecting Dominic Toretto to turn up in a GTO at the end and say, you know, firmly. Race Harry Potter on his broomstick or something.
I wouldn't be surprised at all if Dominic Toretto turns out to be a magical wizard that can fly in the final.
I mean, it's the only place it can go next. It's the only logical next step, isn't it? Either that or lightsabers.
There we go. We'll wait and see.
We'll wait and see.
So on a related note, anyway, talking about me finally getting to go to my admission ceremony, I thought we could tell our audience about our route into law.
Yeah,
because
absolutely.
yours was far from traditional.
It certainly was. Yeah, do you want me to go first? Yeah, I mean, I think I may hold the record for the longest time between finishing the bar course and starting in practice as a barrister. There may well be someone out there who beats my record. Mine is 11 years. If there's anyone who's got a bigger gap between finishing the bar course and starting in practice as a barrister, let me know, because I'd be very curious, and it'd be brilliant to get you on the podcast as well, actually. So if anyone can beat that record, let me know. So my route was, just like most people, went to university at 18. So I'm from Liverpool. All my mates from school stayed at home. What's the point in moving away? So I thought, yeah, I've got a fantastic uni on my doorstep. Let's do it. So I went to Liverpool, got my 2-1, then went to complete the bar course straight after, as most people do, and completed the bar course at 21, the year after finishing my degree. And at that point, I'm applying for pupillage, and as I'm sure many of our listeners know, it's no easy ride trying to get pupillage. And particularly for myself, I'll admit, there was not really a great deal to make me stand out beyond that. A decent degree, very competent on the bar course, many pupillages, but beyond that, nothing really that set me apart. So it was only after finishing the bar course that I started to get some experience. About 2 or 3 months after the bar course, got my first proper job, which was as a paralegal in a PI firm, one of the biggest firms in the Northwest, actually. And I dealt with a variety of different things over the years. And at the same time, whilst I'm working in that role, applying for pupillage. And it was a brilliant role for me because I was instructing counsel quite a lot, so working closely with barristers. So I was getting a bit of an insight into what they do. But also I would often draft particulars of claim on cases. I would go to district judges' chambers to conduct advocacy on a variety of cases, some contested, some not. And I'm also regularly in conference with clients, taking witness statements, so that built up my witness handling skills. So developing all the skills that you'd need as a barrister, which helped me start to get interviews. So for a year or two after finishing the bar course, I was applying for pupillage. I was getting to final round interviews, but just never quite made that cut. So I thought, well, do you know what? I need to get qualified. I was chatting to Michael Stokes, KC, you're going to hear this podcast shortly. And his piece of advice was just get qualified, and I couldn't agree anymore. So I thought, well, I need to get qualified as something. So because I'd done the bar course, I was exempt from half of an LPC. So I was able to do an LPC part-time on a Saturday in 1 year. So I did that, and within a few months of finishing the LPC, managed to secure a training contract with a criminal firm. And it was just a case for me, really, of whichever comes up first, pupillage or training contract, I'm taking. Mm-hmm. And back in those days, you were able to complete your higher rights course as part of the PSC. So I thought, I'm not bothering with any options. I'll replace that with the higher rights, which you can do. Did that. So as soon as I qualified, I was qualified with higher rights and practiced as a solicitor for several years in defence, then moved to the CPS for a few years. And then I decided that, the self-employed bar was for me. That was always the plan initially. That was what I wanted to do. And nothing against the firm that I work for or the CPS, because they were both fantastic places to work. But ultimately, I wanted to be a self-employed barrister. I wanted to be in chambers. So it was the right time for me to make that move. And I did it and haven't looked back since. So that's my kind of convoluted route to the bar. Yeah. A lot of people say, they go to university, and I was the same way. You think, wow, I've got to get qualified right away. If I don't make it to the bar by the time I'm 23, it's game over. My life's over. But the reality is, if you're going to be in this career, you're going to be in it for a long time. You're going to be in this career for decades. So there's absolutely no rush whatsoever. Mm-hmm. And I think the fact that I came into the bar a little bit later meant that I've built up so much life experience in the meantime that I bring to the criminal bar, which helps me in my day-to-day practice, helps me when I'm dealing with clients, and helps me when I think about cases. So I think in a weird way, coming to the bar a little bit later has actually been to my benefit.
Yeah. Wow.
So Hayley, do you want to tell me about your route to the solicitor's profession?
Yeah, sure. So when I was coming to choose what university to go to, it was actually one of my college tutors that suggested Salford University, and that's where I ended up. So she was telling me about, they've got this brand new state-of-the-art law school, they've got really good work experience opportunities, etc. So from there, we went down to visit the campus and absolutely fell in love with it. So the Lady Hale building is their law school. And another thing they did that caught my eye was they had links with some law firms, and they did what was called a 4-year degree for lucky students that managed to get placements with those law firms. So it became a 4-year degree, a law LLB with professional placement.
Yeah.
So I was really interested in that, but didn't hold my hopes too high that I was going to get it, because at the time when I came to apply, it only went to one student in the year. And by some lucky miracle, I actually did get on that placement. So I worked in a firm called HL Interactive Solicitors. So it was mainly debt recovery litigation that we did. And I went back to work there once I'd finished university. And very shortly after that, we were acquired by a firm called Ascent Group Performance Limited. And they are a wholly owned subsidiary of Irwin Mitchell. So very suddenly, rubbing my hands together, hello, internal candidate for Irwin Mitchell solicitors. So that was a very, very happy occurrence for me. It still took a few years to get a training contract. I had to go through the cycle twice. And I think, like you, John, one of the things that when I got feedback, what I fell down on was not doing enough extracurricular stuff, so not setting myself apart enough from other candidates. I remember at the time being so frustrated because I was being seconded at NatWest Bank at the time. So I used to go to Birmingham and stay in a hotel for like 3 days, then come back and work in Manchester for 2 and carry on working a full caseload. So at the time I was like, you want me to go play football or something as well? Like, my God, what do you want me to do?
Yeah.
It's so competitive, isn't it? And it's like, you've got to make yourself stand out. So I think that when I was getting ready for the next cycle, I joined every single committee that Irwin Mitchell had. So I was in the CSR committee, the Prince's Trust charity committee, the social committee, everything. I was like, okay, we are going extracurricular crazy. And I actually really, really enjoyed it. And also it meant that when it came to apply for the training contract again, I was very, very integrated in the firm. So I knew everyone very well. Everybody knew me very well. And also, having gone through the assessment process the year before, when I went in for it the final time, I was really armed and ready. I knew exactly what to expect.
Yeah.
And lo and behold, finally got a training contract.
Congratulations.
And then I had to wait 2 years before I could start it, because they recruit 2 years in advance in most big firms, don't they? So I worked in compliance for 2 years and really, really enjoyed that.
Yeah.
And I think, like you said, John, all the experiences that I gained during that long process all went towards helping me along the way and in my legal career. So the things I learned in risk and compliance massively helped me as a solicitor. And lo and behold, 4 years later, I've very recently left private practice to take up an in-house role at the JPD Group Limited, which, if you don't know, that's a company that incorporates speed mooting, advocacy club and public speaking tuition. So that's a very recent move for us, isn't it, John?
Yeah, very recent indeed. Welcome to the team.
Thank you.
Yeah, funny you mentioned Salford. We ran into Lady Hale a few months ago, didn't we?
We did. We went down. We were in London again, weren't we?
London.
Oh, this one we went to get your wig.
Yeah.
You've got to tell the story about us travelling to London to get your wig.
Oh yeah, absolutely. So this is me transitioning to the bar. So we travel down. We make a weekend of it once again. You travel down with my mum and dad. They love going to the Inns of Court. We always stay at Gray's Inn, and it's either the Friday or the Saturday. I can't remember which. And we go to Eden Ravenscroft. We go in, speak to the gentleman, take us into the back, and he gets me a gown out. brilliant, try that out. Yep, feels good. Right, we need a wig now. Measures my head. Oh, I'm afraid to say we've gotten on in your size. It was call week last week and we've been absolutely inundated and all of our wigs are gone. I remember ringing my clerk because I was due to start in chambers the following week. And I said, I'm not going to be in the Crown Court next week, am I? He goes, yep, you got an appeal next week. I'm like... So then lo and behold, one of my mates is a family barrister. So for those of you that don't know, those in the family court don't tend to robe. They just wear suits in court. So my first couple of weeks at the bar were spent in a borrowed wig. And then we went back to London a few weeks later to get the wig, didn't we?
We did.
So yeah, but what was interesting was we went to Sunday lunch as well. And for those of you who are a member of the Inns of Court, I highly recommend a Sunday buffet lunch, particularly at Gray's Inn. Now, to me, a buffet is sausage rolls and spring rolls and chips and sandwiches. No, a buffet is a very posh carvery at the Inns of Court. So the day starts, we go into the pension room, and before Mass, we have drinks, and we see Lady Hale. So I'm turning around to Hayley, man.
Yeah, I just remember John nudging me. Look who it is. And I'm like, who? It's Lady Hale.
So Lady Hale's there making a cup of tea for herself. So I thought, well, I'll go and stand next to her and make a cup of tea myself. And
your opening line to Lady Hale, I remember like it was yesterday. Oh, hello. I hosted a competition in a building named after you.
So to put that into context, for those of you, I imagine most of our listeners know, but our flagship competition is the National Speed Mooting Competition. And every year it moves to a different university. And funnily enough, our first ever national competition was held at Salford University in the Lady Hale building. So I thought, yeah, so that was my icebreaker to Lady Hale. And we had a lovely chat with her, didn't we?
We really did, yeah. We were really lucky because for whatever reason, it wasn't massively attended that day, was it? So
no.
When we all sat down for our carvery lunch, we all got to sit on the benches table.
Yeah.
And we actually got to sit next to Lady Hale.
I sat next to her, didn't I? Yeah.
Very nice.
So in terms of our day, so we had drinks beforehand, didn't we? Then we went in for Mass. Mm-hmm. Then after Mass, we go back into the pension room for more drinks. And then we go for the meal itself. And it was really high quality beef, nice potatoes, vegetables, gravy. And we got a starter, and I feel like I should be doing a food review of this, shouldn't I?
Yeah. So come down.
10. But no, it was brilliant, wasn't it, Hayley?
Really, really good.
And nice food, nice company. So yeah, we had a good day.
Definitely. So for those who are members, as John said, get down as often as you can. You never know who you'll be sitting having Sunday lunch with.
No. I mean, that reminds me years ago, back when I was on the bar course, and I used to go to London for the dining sessions. And on one occasion, I was the junior in hall. I suspect it would have been the under treasurer comes over to me and says, "You're the junior in hall today, and therefore you need to toast domus." So what that means is that at the end of the meal, the junior is required to stand up, propose a toast to domus. And then that means that everyone effectively at that point can leave. I think traditionally, it meant that people could have a cigar at that point. I think I could be wrong on that, but obviously with the current legislation that can't be done anymore.
No.
So me being me took the opportunity, and you had to stand on the bench to do so everyone could see you. And I took the opportunity to make a bit of a speech out of it. So instead of just the 3 or 4 words you're expected to say, I said, something along the lines of, we're all going through exams. I wished everyone the best. And it was also my dad's birthday as well. So I got everyone to wish him a happy birthday.
Very nice.
Yeah, so good fun.
So I think a nice little theme we've got going in these podcasts, John, is to tell people whatever you've been doing in court that day. Absolutely.
So today I was on a first appearance. All criminal litigation starts in the magistrate's court. So whatever you're charged with, whether it's, stealing a 1 penny sweet or whether it's murder, you will always go to the magistrate's court for your first appearance. And the purpose of that hearing is to enter your plea if it's an offence that can be dealt with in the magistrate's court. So today's offence was what's known as summary only, meaning it can only be dealt with in the magistrate's court. And so what you would do at a hearing like that, if it was going to be a guilty plea, a guilty plea would be entered, and then the person who's representing the defendant, whether it's a barrister or solicitor, would present a plea and mitigation on behalf of their client at that hearing. So the case is all concluded in one sitting. Alternatively, if your client is going to enter a not guilty plea, the client will, of course, enter that plea on the first appearance. And then what we would do is we complete a form. It used to be a paper form, but it's now digital. And at the hearing, we'll set out what the issues are for trial, and we'll get a date listed for trial normally. Or occasionally, you might have an additional hearing between the first appearance and trial called a case management hearing. And I think I spoke about that maybe on the last episode.
Yep.
So the first appearance is really about getting your ducks in a row. It's either guilty plea, mitigation, or it's not guilty plea, and let's get a date set for trial. Now, of course, some offences are indictable only, meaning they can only be tried in the Crown Court. And for offences such as that, what the court will effectively do is they'll just list a following date for a PTPH. So you go to your first appearance in the Magistrates' Court, and then the court will then give you a sending date. Or it might be a case where it's an either way offence, which is an offence that can be tried either in the Magistrates or the Crown Court. And if either the magistrates deem it's too serious to be dealt with in the Magistrates' Court, or the defendant elects a Crown Court trial, you will then receive a date for a PTPH at the first appearance. Sometimes, you might enter the plea at that first appearance as well, or at the very least make an indication as to plea. But the first appearance very much gets the ball rolling in relation to the case.
Nice. Okay, so we did a post recently, and it was really simple, common mistakes to avoid in advocacy. And we gave 2 really simple examples, but then lots of people started commenting on our LinkedIn and throwing in their own examples as well. So I thought we'd discuss those very briefly, because there might be some really useful hints and tips in there for people.
Yeah.
So the first one is incorrectly addressing the judge.
Yes.
Is this really common in practice, or is it something that doesn't happen very often?
I don't recall ever seeing it. It may happen from a slip of the tongue.
Yeah.
But for the most part, you'll probably find that people are addressing the judge correctly. And most people, if they do have a slip of the tongue, correct themselves right away, because most people who are in practice know how to address the judge. So the general rule is, if in doubt, elevate. So what I mean by that is, let's say if you were unsure with your specific judge whether they should be addressed as Your Honour or My Lord, with an abundance of caution, say My Lord.
Yeah.
Because the last thing you want to do is downgrade the judge. They're never going to mind being upgraded. They'll certainly mind being downgraded. But what you might see is practitioners who maybe have a split practice between the magistrates and the Crown Court, whereby in the Magistrates' Court they might be in front of a female judge and addressing them as Ma'am, and then in the Crown Court addressing a judge as Your Honour. So they might say Your Honour, Your Honour, Your Honour, and then at one point accidentally say Ma'am. It's understandable, but then they'll probably correct it straight away. So the judge will know, because they've been addressed correctly all the way throughout, really. But so I've seen that sort of thing happen before. But as a general rule, most practitioners know how to address the judge.
Yeah.
But as a student, it's really key. It's key to know how to address your judge. With mooting, you're always in the Court of Appeal or the Supreme Court, so it's always My Lord, My Lady.
Yes. Okay, another one we've got is for very new advocates. If they're really nervous, sometimes they can try and mask that by appearing really aggressive or really arrogant.
Yeah.
And we say there's absolutely no need to do that. So I think you've got experiences, haven't you, John? If you're new, there's nothing wrong with telling your opposing counsel. And it's always really surprising, isn't it, just how friendly and cooperative most people are, even if they're on the opposite side to you.
Absolutely. Most are friendly. I would say 99% of the people I come across are quite friendly. So if that's the case, as you say, don't try and mask it by being arrogant, trying to be over forceful, particularly when dealing with your opponent. Be friendly. I remember my first ever case in court, newly qualified solicitor, and Bootle Magistrates' Court it was. Just very, very straightforward plea hearing or something. And, told my opponent about it when I went to see him in the CPS room, and very, very friendly with me. We had a good laugh and just really helped me out, actually. So there's nothing wrong with that at all. I enjoy my job. I like to be happy, and I like to treat everyone with respect, regardless of whether they're on the same side as me or whether they're my opponent. And that's the way everybody should be treated. At the end of the day, we're doing a job, but we're there to serve our clients, but we're doing a job at the same time. So as you say, Hayley, most people will treat you with respect, and I think that comes on to another tip I'd give is just be nice to your opponents, be nice to people, because it serves no purpose dealing with your opponents unprofessionally.
Okay, the next one we have is to avoid using complex and convoluted language.
Yeah.
I think this was your comment, actually.
Maybe actually, because there's a reason I say this, because quite often a simple argument is an easy argument to follow. It's not a general rule, because some people can really use the English language to their advantage. And if that comes naturally to you, do it, because it sounds really, it does sound good. But for the most part, it's something you have to think about and something you have to put on.
Yeah.
And if you can say something in 5 words versus 10 words with flowery language, do it in the most simple way, because you've got more chance of tripping yourself up, which makes you look unsure. And secondly, if you're using complex language that your jury might not understand, a judge might not understand, magistrates might not understand, well, what's the point of making an argument that can't be followed? So what I say is keep it simple, unless you've got that natural flowery style, which does sound incredible when you see somebody pull it off well. But unless that's your natural style, keep it simple, I say.
Okay, so the next ones are coming from a few comments that we had on this post. So one of our comments we had was to make sure you're in the right court.
Yeah.
You probably think, oh, you'll never make that mistake, but I bet it happens. So always double check.
Always double check. I always double check my diary before leaving the court, leaving the house in the morning.
Sometimes there's more than one in a particular city, isn't there?
So, for example, Manchester has 2 Crown Courts.
Yes.
So you've always got to check
which one you're in. This one, don't respond to a judge by saying, it's not my file. Oh, the temptation must be there.
I mean, you say that. I mean, in the Crown Court, you'll often hear, I'm not trial counsel. But yeah, no. Try not to fob it off on somebody else. Try not to throw somebody else under the bus. Because ultimately, if you've been given the task of going to court, you're expected to know your stuff.
And another one we've got is to make sure you take all the relevant paperwork and all the relevant documents with you, which is interesting because when we were interviewing Michael Stokes for his podcast episode, which will be released shortly, and that was one of the things he said from the point of view of being a judge, that it's really frustrating when people aren't prepared properly.
Yeah.
So a really key thing to get right is to make sure you've got everything with you. So if a judge says, can I see that? And you're flicking through your papers, oops, I don't have it.
Yeah.
It obviously slows everything down and
it really does.
Throws the case into chaos.
And I think stemming on from that, make your life easy. So if you've got a physical folder there with physical papers, tab it up so you know how to find things easily. Or if it's on a computer system, try and have some systems so you can find things nice and easily. And also, try and make a chronology for yourself as well, because sometimes you might be asked by the judge about a date when something happened. So if you've got a chronology of all the key dates in the case, it makes life so much easier for yourself. Chronology of everything that's happened, particularly at previous court hearings. So putting a chronology together is really important.
So I think that probably brings us to the end of another episode.
It certainly does, yeah. We're 5 episodes in.
We certainly are. So we've got a nice bank holiday weekend to look forward to. What are our plans for that again, John?
So no doubt I'll get the cart out at some point.
Yep, you'll do a bit of racing. Oh, we're going to go to that, there's a monkey park by Stoke-on-Trent that I found this morning. So I sent it to John and said, we're going to go here at some point over the weekend, so you can walk through like a huge park with just monkeys running around and roaming everywhere, so we're going to give that a try.
That'll be fun.
Apparently we're going to get some nice weather as well. So
yeah, it's about time. We're basically in May, we've not seen any sun yet, so...
No.
Yeah.
So everyone out there watching, we hope you have a really, really nice bank holiday as well, and we'll see you here next week.
Yeah, perfect. So that was another fun episode, and see you next time.
Bye.